Welcome everybody to the May 2026 Case Update Reviews, sponsored by Veritas Workplace Investigations. This month, we're going to discuss all of the cases we were able to find concerning employment law in California. We're going to try a little bit of a different format, which is going to be a conversation between George and I. So George, on that note, I think we should begin talking about the case of Crowe, my pronunciation, versus Averill. And this is a case that deals with a bisexual police officer who complained to the force that he was being called names, and the names are published, but I don't feel comfortable saying it in this recording. But let's just say that they were offensive terms, suggesting that the person was a homosexual, and these are well-known insults, or at least to me, they seem like insults. And when the police officer complained, one of the responses of the employer was that these two terms used repeatedly were not offensive enough to create a hostile work environment. For that reason and other reasons discussed in the case, the employer was able to get summary judgment, so they quickly won on the papers without a trial. The case went to the Court of Appeals, and the Court of Appeals decided, as they often do, not so fast. This is a case where a trier of facts, in this case a jury, they need to decide whether these two offensive words or these words were actually offensive enough to create a hostile work environment. And without looking at the words for purposes of this recording, I think that what we can talk about, George, is the fact that the law has not changed, and the law still says that conduct that creates a hostile work environment may be in violation of law, and that a comment, even if isolated, and that a word, even if used only once or only a handful of times, may be enough to create a hostile work environment if the word is offensive enough. What has changed is that our society is a lot more coarse. Our society is a lot more tolerant of foul language and bad words. And people think that using bad words at work is not going to get you in trouble. And who cares? How can somebody make a claim of discrimination? How can somebody make a claim of harassment based on a word that we can see on TV, and let's not even talk about social media, right? So this is a reminder, I think, that even if society believes that it is okay to use bad language at the highest levels of society, in the workplace, it's unacceptable, not tolerable, and even a couple of words that may or may not be offensive could cause a hostile work environment, and it is up to a jury or a judge to make the decision of whether the law was violated by the use of those words. So that's my take on this case. George, I don't know if you have a different take. What say you?
As usual, the devil's in the details. Each case has its facts. And here, the coworker repeatedly called the bisexual officer two slurs that both begin with F, referring to homosexuals. And it was in front of other people, and it happened over a period of time. But an interesting fact is that this harassing officer was then assigned to investigate and take statements from other officers. And of course, he only picked the officers that would support his side of the story. So there's always the interesting little tidbits and extra facts. And you're right, Javier, the law hasn't changed. It's still severe and pervasive. And what we consider severe and pervasive may change over time, may very well change over time. I still think there's some radioactive words, and I think these are either in or close to that category. And so the court decided there were sufficient circumstances to infer discrimination, and it survived summary judgment.
And in that case, the company got summary judgment, right?
This is an appellate court case, yes.
So they won.
So this went up to the Court of Appeal.
So in
And
that sense, and I'm sorry to speak over you. So in that sense, what I wanted to go back to was that the fact that a court looked at the F word concerning homosexuals and said, so what? That's not enough. There were other issues, but just looking at the potentially offensive language, they said that's not enough. There are some words in society that are still radioactive, like the N word, right? Nobody will, in their right mind, will use that at work and not even on the internet, right? The R word is also one of those that are unacceptable in society, but in 2026, concerning sexual orientation, dealing with somebody who is bisexual, what were the words offensive? And it seems that this court said that's not enough to create a hostile work environment. And the Court of Appeal had to remind everybody, say, no, so fast. You don't get to decide that.
you're right.
It's the language.
You're right. This was a reverse and remand. So they sent it back down, reversed the summary judgment, and sent it back down to the trial court.
And the reason why I wanted to go back to that, Judge, is to dramatize how important it is that even if society is more accepting of bad words and foul language, the courts should not. That's what the Court of Appeal said in this case, right?
Right. And just for clarity, this was a Ninth Circuit Court of Appeal. So it went back down to the district court, where the judge down below had granted summary judgment.
Interesting. So we agree that this is the right law, and we agree that this was the right decision. Do we agree?
I think so, especially from the plaintiff side. I don't like supervisors calling their subordinates names. I don't like the supervisors being put in charge of the investigation. I don't like the supervisors picking who they're going to interview. Absolutely, I think it was the right decision.
So that means that we need to find another case, because if we both agree, then there's no banter, no discussion. Let's see what happens in the next case. I think it's a husband case. So, Judge, what happened there?
This is Husband versus Target Corp. An employee was acting erratically. The employer fired them, and then the employee said, well, I was acting erratically because I have a mental illness, and you should have known, or you should have investigated. So rather than fire me, you should have accommodated me. Therefore, you violated the law. You didn't engage in the interactive process. You didn't provide an accommodation. You retaliated against me for having a disability. And he filed a case for wrongful termination. However, what the court found in this one was the behavior being exhibited wasn't behavior that suggested to the employer that he had a mental illness. This behavior could have been simply someone who was drunk, or someone who was sleep deprived, somebody who's misbehaving at work. So it brings up the question, is an employer obligated every time somebody violates a company policy to consider the fact that it might be a mental illness or a disability of some sort? And this particular court said, the employer has the right to terminate somebody based on their conduct. And if there's no reasonable indication that the misconduct is the result of a disability or a mental illness of some sort, then they can lean on lack of knowledge of the disability, and that negates one of the elements of the claims. So of course, a company has to know about the disability before they can be on the hook for discriminating based on that disability.
So do you agree with this decision?
Logically, I agree with it that knowledge is necessary. As I always keep saying, the devil's in the details, and just exactly how bad was his behavior. I think in this case, I think it's fair to say that the company simply saw some misconduct and terminated, and was never put on notice that it might be related to a mental illness. So my answer has to be it's going to be a case-by-case basis.
And the reason why I ask you that question is because this is the reason why we're gainfully employed. The reason why we have a full-time job is because the law imposes a burden on employers, I think. And the law says that an employer cannot discriminate based on a mental condition. But the law also says that an employee cannot be treated as if the employee has a mental condition. The phrase is regarded as having an impairment. So if the employer either knew that the employee had a mental condition, the law says, or the employer treated the employee as if the employee had a mental condition, that would be a violation of the anti-discrimination laws. So in this case, if the employee was acting crazy and the company thought that the employee was acting crazy and the reason for termination was the craziness of the conduct, the argument could have been made that they treated him like crazy, which crazy is just shorthand, an offensive way of saying that somebody has a mental condition. So this was a close case, and I think that the employer was lucky here because this could have gone the other way. And this is,
Go ahead.
yeah, go ahead, George.
I think you're right. Let me just sort of recount the incidents. The first incident was that he came to Target while he was off duty, and while he was there, he used profanity and got upset with an employee. He was counseled for that incident. The second incident is that he showed up for his night shift, quote unquote, looking very deflated, and then, quote, got suddenly very angry. And then he said that he'd been hitting himself in the temple and that the fulfillment of the workload themselves were laughing at him. He became highly emotional and visibly upset. I don't know, man. Maybe the employer should have been looking into that, right? The conduct was out of the ordinary for the plaintiff, and it was called somewhat disturbing. And then the third incident, he showed up, quote unquote, looking shaky and distraught and breathing heavily. And he told coworkers that he thought he killed his stepmom by speaking a word. And so I don't know. As I'm sort of thinking through these incidents, maybe the employer should have had a duty to look into this.
And that's the conversation that I wanted to have with you about this case, because I agree with you that the court's message that an employer is not required to go down the list for absolutely every possible reason every time somebody misbehaves, although the burden should not be as high as requiring the employer to just check all of the boxes, right? In some cases, it's just common sense. If somebody is acting in a way that is erratic, and like the facts that you described, I think that a reasonable human resource person should have said, like, is there something going on here? Right? Is there something more that we should do with this conduct, right? But just saying, don't ask, don't tell. I don't know. I don't want to see it. I don't want to hear it. I don't know. I didn't know. I had no clue. Worked in this case for this employer, but that may not be enough. That's my point. Just claiming ignorance may not be enough. If you sincerely had no idea that this person was behaving because of a mental condition, I think that's a legitimate defense. We had no idea, and the conduct did not suggest that the person had a disability. But in this case, the conduct seems to suggest that that something was going on. That's my point.
It's a weird double-edged sword that the more erratic someone behaves, the easier the decision is to fire them. But the more erratic they behave, the more they might be in a protected category, which doesn't let you fire them, putting the employer into quite the quandary. But based on the facts of this case, if I was the plaintiff's attorney, I'd be appealing.
And as an employer, you have to grab onto this case and just hold it very close to your heart and use it every time, because it's like, look, we had no clue. We had no idea. The conduct could have been interpreted in multiple ways. And if there's more than one explanation, how can it be discrimination, right? Right?
Well, again, devil's in the details, so we weren't there, and but just reading the incidents, and there was even one more after he got fired where he seemed a little bit crazy. Again, if I was the plaintiff's attorney, I'd be appealing.
So this case is definitely going to make its rounds. Everybody's going to cite it one way or the other, and it's really, really interesting. So this is a gem. Don't forget, Husband versus Target Corporation. Let's see how long it lasts as good law. Which takes us to,
I said right.
Right. Let's see how long it lasts as good law. My bet, and this is a prediction, 1.5 years. So let's see what happens. Let's talk about in July of 2027, if this is still a good case. George, which takes us to the next one that we have on our list, is the Flowers Food versus Brock case. What's up with that?
Great case for plaintiffs. There's always been a back and forth and a split of opinion about whether a worker who transports goods inside of one state without ever crossing state lines can qualify for the exemption from arbitration afforded by 9 U.S.C. 1, which says workers who transport goods across state lines are exempt from the FAA provisions. But the debate has been, well, what if there's a load that comes from out of state, but then when it comes in state, someone drives the last leg, never leaving the state in which they're in, and whether that person is involved in interstate commerce or not, and therefore whether they get exempt from arbitration. Well, this is a Supreme Court case that says they do, even if they are driving goods and they didn't interact with the other truck that came from out of state, and didn't cross state lines or even interact with the vehicle that crossed state lines. They still, because they're on the last leg of an interstate journey of the goods, they're still an interstate transporter and still get the get out of jail free card from arbitration. Of course, from the plaintiff side, I think this is a wonderful decision.
Now, to go over what happened, right? If an employee is in transportation, and transportation is part of the interstate commerce, which means that is the commerce between one state and another state, those employees cannot be forced to go to arbitration, right? That's the basic rule.
Right. Section 1 has that exemption.
So this is pretty unique to transportation workers that deal with the commerce of two states. And for the longest time, if somebody was part of the chain of transportation, but the employee that was part of the chain of transportation did not actually leave the state, then that person was not protected by this exemption. Because if the person never left the state, how can that person be in the interstate commerce? And this came up many times, especially on what is known as the last mile, a phrase used to describe the people who actually bring it from another state but distribute it within a state, right? How can somebody in the last mile be in the interstate commerce? If they're in the last mile, they never left the state. And the United States Supreme Court has said, like, well, they do because, and what's the reasoning, George? Because
the goods that they're delivering came from out of state.
So this is a big deal.
It's a very big deal, and it makes me think of this. When I order something from Amazon, I live in Tustin, California. There's an Amazon center within about 2 miles of my house. Sometimes I get my order in the same day. So nothing happened interstate, but the goods that I got very well may have come from out of state. And so the driver who drove 2 miles from Edinger to Red Hill to my house may be protected now.
That's right. That's right. And, it should be the commerce between the states, because most of the stuff I buy comes from China, which is not even in our state. But all kidding aside, this is a big deal in the sense that now the law has changed, and this doesn't apply to many workers. But the reasoning that interstate commerce now includes somebody who has never left the state allows for creative arguments going forward. At the highest level, the United States Supreme Court says, like, of course, somebody who only drove the last mile is in the interstate commerce. There are many other rules that can be challenged, even if they defy logic on the basic definition of what interstate means or what the exception is. So on this one, I take it you approve?
Of course.
I have to disapprove, because a worker who never left the state, how can they be in the interstate commerce?
The goods are.
The goods are. I hear you. All right. So I think we have another case. And this is the Toothman versus Redwood Toxicology Laboratory case.
Yes.
Another case published in the Mail in May of 2026. And in this case, this is really interesting to me because what happened was that an employee started working for the employer through a staffing agency. And the staffing agency had an arbitration agreement with the employee that clearly said that it was between the employer, staffing agency, and the employee. If they had an issue, they needed to go to arbitration, and that was that in California. But then this employee was hired by the client company of the staffing agency. And after working for the client company, a new employer, there was a dispute, and the employer wanted to use the arbitration agreement signed by its employee and the staffing agency where the person worked before. And the question was, can the real employer benefit from the staffing agency's arbitration agreement because it's the same person who signed the agreement? And the decision was that no, it cannot. That cannot happen because the parties to the arbitration agreement were the staffing agency and the employee, not the new real employer, and not even under the theory that this was for the benefit of the client company. You see, if the employee is working and the employee is working through the staffing agency, and then the client company is sued, the argument could be made that maybe that employer should benefit from the arbitration agreement because the employee of the staffing agency at the client company, the arbitration agreement covers the client. But in this case, there was a separation because the person stopped being the employee of the staffing agency and became the employee of the client company. So logically, looking at it from outside, it seems logical that that's the right decision. But I think that there are very many cases in which employers argue that the arbitration agreements with another party benefits them, or that they are included in the definition of employer, or because it's the same person, is fair game. And in this case, the Court of Appeals seems to be rejecting that and saying like, this is clear, people. Who's the employer? Is the employer signing the agreement? And if the employer is not as part of the agreement, they cannot benefit from arbitration. Is that what happened, George?
That's basically what happened, and you did a good recounting of everything. And there's this clear dividing line that you don't often see, where the staffing agency is his former employer. He no longer works for them. Often we see that someone's working at the client company through the employment agency, and at the same time, so both entities are live defendants. And so we have, even if we had the same situation where he didn't quit the staffing agency and start working for the client company, we'd have some real good arguments for third-party beneficiary. And even here, they did argue we're a third-party beneficiary of this arbitration agreement. That clear dividing line of having quit working for the staffing agency, I think, was the deciding factor. That some former employer that I used to have, if I signed an agreement with my last employer, doesn't mean my current employer gets the benefit of that agreement.
In this case, the trial court said no arbitration for you. If you didn't sign the agreement, you cannot arbitrate. But the employer appealed, and the Court of Appeals said no arbitration for you. You're not part of the agreement. Now, can we criticize this employer for taking an appeal on something that seems to be clear? My response is like, well, we just saw how the United States Supreme Court said that somebody who never left the state is part of the interstate commerce. So I guess it's no harm in just trying. This was a class action after all, and there is so much liability and potential liability behind it that maybe this employer thought that they had a fighting chance. I don't think they did, because as you mentioned, this is not the case where the employee of a staffing agency is suing both the staffing agency and the client company. That's one thing. What happened here is that there was a separation between the client company and the staffing agency, and this individual, the named plaintiff in the class action, was a true employee of the defendant, right?
Absolutely. And the court said something interesting, that even if the the employer could be considered a third-party beneficiary, Well, the agreement didn't cover claims that arose out of employment with the employer. It had to do with the staffing agency. So there was problems with the agreement itself, in addition to the non-signatory problem. But to answer the question you asked a few minutes ago, did it make sense for the employer to do this? Well, there's an equity and inequity that I don't like. And that is that if a trial court denies a motion to compel arbitration, the employer has an appeal of right. They can just go up to the Court of Appeal, and there's really no consequences to them trying that appeal other than wasted time and wasted attorney's fees. So it's a low impact, low risk appeal. The absolute worst case scenario is they are right where they started, and they put the plaintiff through a few more hoops, theoretically dragging them down and making their energy, sapping their energy for the case. So I think it's a strategic decision that gets made, as opposed to, do I think I'm going to win? On the flip side, if an employee loses a motion to compel arbitration, they don't have an appeal as right. They have to go through the writ of mandate process. And most of the time, the Court of Appeal can just deny the writ with one sentence saying writ denied. They don't even have to take the appeal. So we have that, what I think is a grave inequity, that one party can appeal the decision in a motion to compel arbitration and the other party cannot. So we have that problem. And secondly, let me just say this real quick before I forget, that in the old days, there was a question as to whether attorney's fees were available or not after the argument over the arbitration agreement had been ended and the case in chief started. But the California Supreme Court has said, no, you have to wait till the end of the case for fees. So the employer has no risk of paying attorney's fees if they lose. They have no risk of the decision being any worse than it already is. So should the company have appealed? Strategically, yes. Logically, maybe not.
And that's what I was going to say. I was going to say that these fees do attach. I mean, this plaintiff is not going to forget how much time they spend on the appeal. So even for settlement value purposes, there's a lot more money on that liability bucket, I think. And on the issue of the Court of Appeal taking cases from plaintiffs, every month we have arbitration cases. So I agree with you that most are not denied with a simple, get out of here. But every month we get new arbitration cases because California, no secret, does not favor arbitration in employment cases.
Yeah, it still seems unfair that one side has a right to appeal and the other side does not.
As a matter of right, I hear you, but as a matter of actual practice in the state of California, it seems that the courts do, seems to me, that the courts do try to find a way to get employees out of arbitration, if we look at the decisions in the last couple of years.
You're right, and it depends on the judge, of course.
It does. All right. So with the employment cases that we had this back and forth discussion, now we are going to turn into what I'm going to call the First Amendment corner. So thanks to George, we're going to have hopefully a First Amendment corner going forward. Maybe there are other important rights that come up, and we may change the name but for this month is all squared in the First Amendment. George, we have a couple of cases that we want to just opine publicly. So tell me about the first one. What did you find out?
Okay, the first one is called First Choice Women's Resource Centers, Inc. versus Davenport. This is a United States Supreme Court case. What happened here is that the New Jersey Attorney General sent a subpoena to a religious nonprofit organization demanding the identities of people who donated to this nonprofit organization. Now, this nonprofit organization is against abortion. So the organization brought this to court saying, hey, we have rights of free religion, of free exercise of the religion, and asking for a donor list is going to chill our free exercise of our religion if suddenly the government has a list of the people that they don't agree with. The lower courts both started off by asking about the standing issue. One way to get a case out of court before even reaching the merits is to say that the plaintiffs don't have standing. And the two lower courts said they don't have standing. The U.S. Supreme Court disagreed in a unanimous decision, and realizing that we have a variety of opinions on the Supreme Court, it's a little surprising that it was a 9-0 decision, that indeed this organization had standing to challenge this subpoena on First Amendment ground. So the case isn't over, but it does at least stand for the fact that donors to groups that have viewpoints can get First Amendment protection from the government. Bear in mind here, this is not just a stranger asking who donated to this organization. It was the New Jersey Attorney General.
So let me see. What I understand happened in this case is that the state of New Jersey officially wanted to know who were the people giving money to this organization that its stated purpose publicly was to oppose abortion, which may or may not be a right in the state of New Jersey, right?
Correct.
And the court said, like, well, the organization doesn't really have the right to sue because the organization cannot speak on behalf of its members. And for that reason, this should not be a case. And the Supreme Court decided that the disclosure of the actual members or benefactors or people who contributed money to the organization by itself was a harm. And for that reason, one of the reasons why this is a case in which the government should be stopped from trying to harm the right of those people that gave money to support something that is religious in their belief, right?
Sure. Yeah, the group is a religious nonprofit organization, so they do have a religious angle to this. And so the Attorney General is trying to say that the organization itself, who brought the suit, the donors didn't bring the suit, the organization brought the suit. The Attorney General is trying to say that the organization did not suffer any First Amendment injury, but those and therefore lacked standing. But the Supreme Court did not accept any of those three reasons.
Under the logic that the people who gave the money probably share those a religious belief that is going to be harmed if the disclosure is made.
Sure, right. The First Amendment being free exercise of religion. The donors, if their identity is revealed, the donations may dry up, and therefore the organization suffers an injury.
On religious grounds. And the reason why I'm asking all these follow-up questions, George, is because I think that if I was a justice on the Supreme Court, which I will never be, I agree with this decision because it does have an effect on somebody's faith and their belief on whether abortion should be allowed or not. It's pretty square within faith-based decision making. But having said that, even though I would have voted to not allow the state of New Jersey to look at the list, there are other instances in which there is money out there that should be disclosed. And I'm talking specifically about political contributions, right? I don't think that you have a right to contribute blindly to politicians and for nobody to know who contributed to politicians. But that's a different First Amendment discussion that we will save for another time, right? But going back to the First Amendment corner, George, is there another First Amendment case that we all should talk about this month?
There is a second case, the last one we'll talk about today. It's Thacker versus Trump. And in 2025, federal agencies began terminating research grants en masse based on different criteria, but one of the criteria was based on viewpoint. Somebody from the Department of Government DOGE, D-O-G-E.
Efficiency.
Efficiency, sorry.
That was the purpose.
Did a keyword search, and some of the keywords that they were using were diversity, equity, inclusion. And using this keyword search to target certain grants to be canceled. And so what the court ended up finding, this is the Ninth Circuit of California, by the way, what the court ended up finding was the federal government has the right to withhold money from certain grants, but not based on viewpoint. So this ended up being a split decision that some of the grants that were canceled for reasons other than the viewpoint of the people who received the money. But the grants where it was clear they were being canceled based on the viewpoint involved, that the federal government can't do that. They can't, you know, it's viewpoint specific. They can't make these decisions because they disagree with the point of view of the people who received the money for the grant.
Now, this is fascinating to me. So let me ask you a follow-up question if you don't mind. So in this case, diversity, equity, and inclusion. The court, Ninth Circuit Court of Appeals, based in California, decided that that viewpoint, right, cannot be used to terminate a grant. But what is the viewpoint? That the administration didn't like that? I mean, what are we talking about?
Well, that's a great question. And the fact that it's the Ninth Circuit probably speaks to whether they felt that was a protected viewpoint or not. But whether one agrees with DEI or not, I personally want the courts to protect all viewpoints, viewpoints that I like and viewpoints that I don't. I don't want the federal government to be making their decisions based on the viewpoint. Either it's a legitimate grant or it's not. And so if it has a legitimate purpose and the grant has been funded in the past, and suddenly the reason for terminating it is based on the viewpoint, I think that falls under let's protect people's rights to speech. Let's say we related this to the previous case. Say one of the other grants was doing research with regard to preventing abortion. I wouldn't want the government to defund those grants any more than I would want the government to defund these grants. So I'm not propounding, I'm not supporting either viewpoint by saying that I don't want the government taking a viewpoint. The whole point of the First Amendment is not that everybody can say anything they want anytime they want. The whole point of the First Amendment is that Congress, that the government can't abridge the freedom of speech. And so when we have the government passing out money to some people but not other people based on viewpoint, I do think the First Amendment is imputed.
And the reason why I ask you that question is because, of course, it is public knowledge that the administration issued an executive order. The executive declared that DEI, diversity, equity, and inclusion programs were illegal. So if the flavor of this administration is that DEI is illegal by itself, they claim that any federal money used to support a DEI program is illegal, and for that reason, they should receive no money. And the Department of Government Efficiency very efficiently did an internal search, and did anything that sounded like, smelled like, or was adjacent to DEI lost their funding. And in this case, the court said, like, you can't do that based on just the DEI component of it. So this is an interesting case, I think, because I don't think this is the end of it.
Exactly. I mean, this case was decided on May 26th, so that's about a week and a half ago. Would it be shocking if this was appealed to the next level? Of course, it wouldn't be shocking. And I think the question you were asking before is if diversity, equity, and inclusion is considered a particular viewpoint, and that viewpoint has been made, I don't think it's been made illegal, but if the current federal administration disapproves of it, can we fund quote unquote illegal grants? Well, I don't think it's been declared illegal by any stretch. And even if that was the upshot of this decision or any other decision, that would certainly be appealed. I don't think we can outlaw diversity, equity, and inclusion. It can be out of favor for 4 years, but I don't think it can be outlawed.
And on that point, that's where this is a clash between the discretion of an administration and the use of public money.
Sure.
When it clashes with the actual First Amendment right to hold an opinion. So this is a fascinating case on the merits. Just either whether you agree or disagree with the declaration that DEI is illegal, at the end of the day, the question is, can the government stop funding because of an idea? We may agree, we may disagree, but in this case, we heard the Ninth Circuit. I don't think this is the end of it. Any predictions, George? Where do you think this is going to land?
Well, if it's at the Ninth Circuit, then next up is the Supreme Court. And we know that the Ninth Circuit is very different than the Supreme Court. So, it could go both ways. It's an interesting argument over the power of the purse, right? And that's probably the most powerful weapon that the federal government has, is how it spends its money. So this is not a small issue, and I 100% believe we're going to hear more about this.
My prediction is going to be upheld, and we're going to know that budget type decisions will have to have other reasons, not just an idea or the idea behind. That's my prediction.
Well, just like we saw a 9-0 decision in that other case with regard to the subpoena for the identity of the donors, despite the United States Supreme Court having various ideologies behind each of the justices, I think we might have that same 9-0 decision going the other way here, where that Supreme Court says we may agree or disagree about diversity, equity, and inclusion, but we have to all agree that the government doesn't get to regulate viewpoint.
That's right. So let's see how well these comments age. George, thank you so much for all the time you invested today, all the time you invested in looking at the cases. We're going to gather again next month to discuss the cases published in the month of June. And between now and then, I thank everybody. If you made it to the end of this video, thank you very much. Remember, Veritas Workplace Investigations, Workplace Investigation in English and Espanol in California. Thank you so much. Thank you, George.